Good morning, friends. One more update from Honorable Supreme Court. The judgment is dated 8th April 2025 and it is in the case of Neha Chandrakant Shroff. As a matter of fact, this case does not relate to the income tax. But the observations made by the Honorable Supreme Court, more precisely with respect to the Writ jurisdiction and alternate remedy, they are very much relevant. I am not going to the facts of this case. Straightway, I read the observations made by the Honorable Supreme Court in para 11 and para 12 of the order. Or rather, one observation which has been made in para 10. This is also one line which is very crucial. Let me read that line first. To ask the appellants to file a suit and recover the possession would be like adding insult to the injury. What has happened here is police department was in the possession of two flats of Miss Neha Chandrakant Shroff. The police department was possessing those flats since many years. Assessee filed a writ petition before the Bombay High Court. The Bombay High Court was not keen on admitting the writ petition, and the Honorable Bombay High Court was more of the opinion that should be filed to get the possession. Assessee knocked the doors of the Honorable Supreme Court, and the Honorable Supreme Court not only ensured that the possession is being given back to Neha Chandrakant Shroff within a particular period of time, but she should also be paid the arrears of rent which the police department has not paid since many years. Now, when the High Court is not entertaining writ petition on account of availability of alternate remedy, now what does the Honorable Supreme Court has to say on this? That is what I would like to read it out for you from the Honorable Supreme Court judgment. Para 10, the important line is, to ask the appellants to file a suit and to recover the possession would be like adding insult to the injury. This is the very crucial observation. At this point of time, if appellants are asked to institute a suit, we wonder how many years it would take by the time the litigation would come to an end, and if at all it reaches up to the highest court of the country. There are the hard facts the high courts are expected to keep in mind in today's time. Para 11 goes this wise. The rule of exclusion of writ jurisdiction by availability of an alternate remedy is a rule of discretion and not one of compulsion. There can be many contingencies in which the High Court may be justified in exercising its jurisdiction in spite of availability of an alternate remedy. This is one of these cases wherein the High Court should have readily exercised its jurisdiction. The constitutional power vested in the High Court or the Supreme Court cannot be fettered by an alternate remedy available to the party concerned. Injustice, whenever and wherever it takes place, should be struck down as an anathema to the rule of law and provisions of the Constitution. So these are the very crucial observation, and this to my mind would be very much relevant if we look it from the angle of the writ petitions which are being filed in the Income Tax Act and which are being dismissed or which are not entertained precisely on the ground of alternate remedy.